Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, Judge of your Webb County Court at Law 2. This is the Family Law Docket for Wednesday, April 22nd, 2026. The time is now 9:02. Court is now in session. Assisting us today are Cecia Rodriguez, Court Administrator and Interpreter. Ms. Cynthia Flores is the Family Law Court Coordinator. Video conference co-hosts this morning include Ms. Noriega, Ms. Ramos, Ms. Cuellar, Mr. Hernandez, and Mr. Lopez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these proceedings are subject to contempt hearings. If you're joining us online, you're instructed to act as though you are in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Rodriguez, Ms. Flores.
In person, Counsel Guadalupe Castillo, page 3, number 6.
Jorge Martinez versus Denise Marie Salinas, cause number 2025 FLA 1199C3. Good morning, Mr. Castillo.
Good morning, Judge.
Court martial present in person. Good morning, Ms. Soto.
Device identified in the virtual courtroom.
Ms. Soto, the court has called your case. Court is asking you to start your video and unmute your device. The court is making that request electronically now. As Ms. Soto comes on, Jorge Martinez, Denise Marie Salinas, are you present? Court marks neither party present. I'll mark Ms. Soto's device logged in. Mr. Castillo, what is the announcement?
Judge, we have a motion to compel filed by Ms. Soto's on behalf of her client.
Judge, can you hear me now? Yes.
Yes.
My computer froze. I apologize, Judge.
We court marks you present by video conference. Mr. Castillo was advising the court that you filed a motion to compel.
I did, Your Honor. We have had 2 settings, I believe, on this matter. This, I believe, might be our 2nd or 3rd setting. We have been trying to reach an agreement, a full settlement on this case. I did email Mr. Castillo some discussions regarding that proposal to dispose of the divorce matter. If I can just have a few minutes, if we can place us on Rico while I confer with him.
Mr. Castillo?
That's correct, Judge. We're very close. I think we have 3 issues pending that should be resolved. Otherwise, the other thing we'll tell the court, we're waiving the jury trial. I think at this point, because of the issues,
Sure.
We don't really need a jury trial. So
right,
we would ask for a trial to the court.
Without knowing anything else, the court will mark this case as the first contested matter to give Ms. Soto and Mr. Castillo some time to confer.
Yes,
All right.
thank you.
Stand by, please.
Thank you, Judge.
Yes, sir.
Person is Counsel Eustorquio Perez, page 1, number 1.
This is Tanya Elizabeth San Miguel versus Alberto Pina, cause number 2011 CVG 2217C3. Court marks Mr. Perez present in person. Mr. Knotson, are you present?
Counsel Knotson is currently at the 49th, Your Honor.
Court will mark him at the 49th. Tanya San Miguel, Alberto Pina, are you present? Please step forward. Ms. San Miguel, step in front of this microphone and tell the court, are you Tanya Elizabeth San Miguel?
Yes.
Welcome to court, Ms. San Miguel. Court marks you present in person. Speak into the microphone and tell the court, are you Alberto Pina?
Good morning, yes, Your Honor.
Welcome to court, Mr. Pina. Court marks you present in person. Your lawyer is in another court. Is anybody here on behalf of the Attorney General's office? All right, so noted. Mr. Perez, what is the announcement?
Your Honor, I spoke with Mr. Marcel Knotson last night, yesterday afternoon, and we have nothing to pre-trial. The only matter that has changed is that Mr. Pina, Ms. San Miguel informed me that Mr. Pina has been indicted in the case that was pending against him, the charges. Other than that, everything remains the same.
Let me ask the clerk and coordinator, since the last setting, has anything been filed for the court to consider?
Nothing has been filed, Your Honor.
All right, so there's nothing for the court to consider. So there's nothing that so in other words, Mr. Pena, it doesn't prejudice you or your case for the court to call this case without your lawyer because neither he nor Mr. Perez have filed anything for the court to consider. However, since Mr. Perez disclosed to the court that there are now some pending charges, flesh that out for me, Mr. Perez. There must be some reason why you brought that up. Are you saying that there's some charges and they're completely unrelated to this case, or is there a possible or potential impact that those charges could have on this case?
At first, Your Honor, when he first got charged without indictment with this matter, Ms. San Miguel, when she came to me, she thought that there might be something related. As I investigated the matter, it did not appear that there was any contact with the daughter. So I would say the only relation is the activity itself, the nature of the activity.
All right, so I guess the court's question was, so for example, if the charges are, and there are charges, that nobody is adjudicating you guilty or not guilty in this situation. I have no idea what those charges are until now. So I guess the question the court has, for example, just by way of example, so if the unproven allegation is that you committed theft against some other person, well, it's not really related to this case because the victims aren't in this case. But if it's something that does impact, and I was just handed the charges. So I guess the next question that the court has, Mr. Perez, the alleged victim or the victim in that case, is it a party or child in this case?
No.
Okay. So I understand that. All right. There being nothing to.
If I may, Your Honor, the court probably remembers the history of this case. It went up to appeal, and I believe that the order that was signed by Judge Maldonado is in effect because it was not overthrown on appeal, and the order that was previously entered in this court is also in effect with the limitations placed by Judge Maldonado. So I believe that's where we're at, and nothing is filed for the court to consider. So,
I mean, I don't know exactly what you're referring to, but I mean, just in general terms, as a matter of principle, as a matter of legal principle, I guess, when you have a valid and enforceable order, the only way to undo it is with another order. So if what you're saying is that there is an order that hasn't been undone, modified, or changed in any way, then you have to follow those orders. Now, if there's two orders that have overlapping issues, then the last signed order controls on those issues that do overlap. I don't know if that resolves your situation.
that's the exact analysis that I've had of it. Now, there was an order of the court,
Okay.
which is still in effect. And when he got arrested, Ms. San Miguel, believing that it might involve the child, came and had a hearing before Judge Maldonado that was signed by Judge Lopez, I believe. And then that got appealed and got.
Court marks Mr. Knotson present in person. Good morning, Mr. Knotson. Mr. Knotson, court called this case at 9:06. Court heard from Mr. Perez that there was nothing for the court to consider. The court then ascertained that and asked the court clerk and coordinator whether anything had been filed. They both, not both, the clerk of the court answered nothing had been filed, so there's nothing for the court to consider today. So I advised or informed Mr. Pena that calling the case does not prejudice his matter in any way because neither you nor Mr. Perez have filed anything. So there wasn't anything for the court to consider. Mr. Perez then told the court that some charges had been filed and it sounded rather vague. So I said, well, does it pertain to this case or not? And I gave an example that, and I didn't know what the charges were. So as an example, I said, if the allegations are theft of something to some other person, well, it has nothing to do with this case. But then I was handed the charges. So the only question that I asked Mr. Perez was, is the alleged victim in that case a party in this case or a child in this case? The answer was no. All right, so at least we're squared away on that. And then he advised the court something about an appeal and orders, and it sounded rather vague. So the only thing that I said on the record was the only way to undo one, as a matter of general judicial principle, the only way to undo one order is with another order. And if there's two competing orders, then the last signed one controls what overlaps. And then I asked, does that resolve whatever it is you were pondering? And I think the answer was yes. And that's where we left off. Mr. Perez?
That's correct, Your Honor. The previous order of this court is, I believe, in effect, in as much as Judge Maldonado's order may have modified some part of that order, which is contact with the child. That order's in effect.
If you're advising me, then I have nothing left to do. Anything else on this case?
Well, I have no idea what Mr. Pettis is talking about. It's very vague, inarticulate, and I don't know what he's talking about. Judge Maldonado, an order in this case, or, you know, I don't know what he's talking about. That's, you know,
I don't know either, Mr. Knotson, but
Yes.
in any event, I have addressed his point, and I have answered specifically as a matter of general judicial principle what happens now. Because there is nothing for the court to consider, there's nothing left for this court to do.
yeah, and I would just ask the court to indulge me for a moment, just from our perspective. When are we set for trial?
April 28th at 2 p.m.
Okay, so that's coming up in short order. So basically, from our perspective, I gave him a proposal that articulated it's been going well, the way the parties were doing it. So I prepared an order. I talked to him last night in advance of today. Well, I gave it to her, but she's not sure, whatever. Basically, what the daughter wants, she's already 15 years old, 16 now. So she wants a standard possession order. If you will
the
recall.
daughter of these two persons?
Yes,
There is one child, 15-year-old female, before the court, 16-year-old female before the court?
yes.
No
And she
other
wants to live with the father.
No other children in
No
this
other
case?
children.
All right, go ahead.
And so basically, you know, it should be like maybe less than a 2-hour bench trial. At one of the last hearings, Your Honor had ordered both parties to go down and do a drug test. If you recall, my client tested negative. She tested positive for marijuana. That was concerning for the court, as would be any judge. So basically, you know, I told Mr. Pettis the offer would be, you know, if she doesn't want to accept this, do the standard. The child's articulate, she's smart, she's mature, for 16 years old. And under the law, it's mandatory for the court to, unless it's not in the best interest of the child, there's no issues that have arisen with the dad with regard to the visitation, anything of that nature. So if they want to go forward, then it's, you know, the daughter's going to testify. I feel more comfortable. I have no problem visiting my mom, but I just want the standard possession.
So let me ask you this, Mr. Knotson, at the final hearing, then ostensibly, this is a divorce case?
No,
This is just a SAPSR.
yes,
So the only issue before the court are child issues.
and I think they were previously married. Yes. Yeah, they were previously married, so.
This was a divorce in 2011, right? So
Yes.
this is just a modification of, so if they're only, let me ask you both this question. If there are only issues related to this child, Mr. Knotson, I'll ask you first, since you had the last word, and then I'll ask the same question to Mr. Perez. Mr. Knotson, between now and April the 28th, what can you do on behalf of Mr. Pina to try to get to a resolution?
I can talk to Mr. Perez to see if they agree to our order. I can do informal settlement conference with the court. I think within 1 hour. I mean, it's not a complicated issue.
Same question to you, Mr. Perez. Between now and April 28th, what can you do on behalf of Ms. San Miguel to attempt to reach a resolution?
Your Honor, based on the indictment that the court just told us, my client informed me of that indictment, and she's concerned now that those charges are pending. She's talked with her daughter. She's very intelligent and very. She loves both parents, but her daughter felt also. She tells me that she should stay with the mother, but that's neither here nor there. I believe we could continue talking because there's some things that she disagreed with in what Mr. Lawson proposed. We could try to solve those issues. But we still have the previous order, which is in effect. And what my client believes is that all of this is just Mr. Pina trying to get away from paying child support because he has not paid in a couple of years. So, that's what she believes.
Yeah, and Your Honor, one other thing we could do is today to help the parties reach an agreement, like you did it the last time. You had both of them go down, do a test. If she comes out clean, that's a positive thing for her. If she comes out dirty, that's obviously something that, for the best interest.
Here's my concern, and I'll express this for whatever it's worth, and not that I need to, but I think you all know, and most lawyers that practice in this court know, is that I don't like when other courts are waiting for me or when I'm waiting for another court to resolve a case. And what I mean and how it affects this case is what I wouldn't want. And this I'm saying this to give you but each of you some ammunition to use during your communications, or I should say some incentives to use. What I don't want is anything in this case to reflect at all any proceedings in any other criminal case. In other words, whatever happens here, I really don't want to be used in any case for one side or for the other. So it sounds to me, if there's going to be any use of that terrible charge in this case, and if it could be that it's unlikely to go in Mr. Pina's favor, but then the reverse should also be used. The reverse should also be true. Nothing in this court should be used against him in that other case either. So all this to say, you need to focus, number one, what's in the best interest of this child, but number two, try to get so that that case is free and clear of anything, and this case is also free and clear of anything going on anywhere else. I hope this makes any sense. I hope this makes perfect sense. Does that make sense, Mr. Knudsen?
It does, Your Honor.
Mr. Perez?
Yes, I'll continue discuss the matter with Mr. Knudsen.
All right.
And just fair warning, Judge, I mean, basically, this is the first time I hear, and I try to talk to Mr. Bettis in good faith. He never raised any of these issues yesterday at 6 p.m. So I'm blindsided by that here, which,
Well, I don't fault you for your sentiments, but that does provide a good ground at this point to begin your conversations. One more time, the instructions of the court are to talk to each other about the best interest and what to do here in the best interest of your daughter,
right,
that has zero impact on anything anywhere else, and the reverse being the case also. All right, Ms. San Miguel, keep in contact with your lawyer. Mr. Pina, do the same. They're going to talk to each other about how best, if at all possible, to resolve your case.
And Your Honor, my client's willing to be sent down to be tested today just to show that he's clean. I don't know if she's willing to do the same, but my client would like to do that just to show there are no issues there on his side. So
As with every single case, if you want the court to consider that, just file it in writing. We'll provide proper notice. And with every case, as always happens, I always do one, but I also do both. So food for thought. Ms. San Miguel, Mr. Pena, keep in contact with your lawyers. I look forward to hearing your case on April 28th. Good luck to
Time
all.
is it at? 9 a.m.,
2 p.m.
2 p.m. Okay,
See you
thank
then.
you, Judge.
Good luck to all.
Thank you.
Thank you.
Excuse,
Yes, sir.
good seeing you.
Your Honor, in person or hybrid? For the notices? April 28th, final hearing in person or hybrid?
Oh, April 28th, 2 p.m. in person. Sorry, I thought you were referencing some other case. Thank you.
Next in person is counsel Javier Montemayor, page 2, number 3.
This is Ricardo Miguel Guerra Jr. versus Julie Reina Medina, cause number 2021 FLI 995C3. Court marks Mr. Montemayor present in person. Sergio Lozano, Francisco Tames, are you present?
Good morning, Your Honor. Francisco Tames, the ad litem, I'm present.
Mr. Tames, the court marks your device present. Do you have access to your video?
Oh, sorry. Sorry about that.
Court marks you present and participating by video conference. Ms. Catherine Garcia, are you making an appearance on this case?
Your Honor, I'm sorry, I'm trying to okay, here we go. No, Your Honor, for the AG's office, this does not concern, child support. It appeared to me to be a possession and access. We are not involved.
Understood. Thank you. Ricardo Miguel Guerra, Julie Reina Medina, are you present? Court marks neither party present. Counsel, what is the announcement?
Your Honor, we are, I conferred yesterday with the ad litem. I need to confer with Mr. Lozano. We're trying to work out an agreement to where we can have some visitation with the child at Safe Haven. But I think that it's been a while since this case has actually been reactivated. I want to say it's probably been a couple of years. And so I think it's important that the child make contact with the ad litem and we can start the process of getting the some supervised visitation in place and get them back on track.
What if anything should the court do at this juncture?
Nothing, Your Honor. It just allow us a little bit of time to confer.
Mr. Tames?
Yes, Your Honor, I did speak with Mr. Montemayor yesterday. And if the parties can work out a visitation schedule, I'd be okay with that. I think that's also in the best interest of the child. I do want to meet with the child and the mother. It's been a while since I've met with them. But if the parties can agree, I think that's always in the best interest of the child.
So let's do a couple of things. I'm sorry, I was pulling up a record now. I'll tell you why in a bit, Mr. Montemayor. Ms. Flores, give us a motion for enforcement setting a final hearing date after May the 26th.
June 4th. June 4th at 2 p.m.
Now, the reason I do this, Mr. Montemayor, Mr. Tames, I hope that you're aware, Mr. Lozano filed an unavailability of counsel notice beginning April 27th through May 26th. I'm treating it as a vacation letter, but I think it sounds like it's for medical reasons. So I think you may have a window, Mr. Montemayor, over the next few days to talk to him. And then he's going to be out ostensibly if he's in recovery or whatever the case is. He may be available, but he may not be working either. So food for thought. I'll set it after his notice ends. Hopefully that doesn't impact you, Mr. Tames, and your work and your access to each of the parties.
I'll send an email right now, Judge, requesting a meeting. So that way, even if he's not indispensable, maybe I can still meet with the mom and the child. And Judge, I couldn't hear the date of the hearing, the final hearing.
June 6th at 2 p.m.
Got it.
Sorry,
June 4th.
June the 4th.
Got it. Okay. At 2 p.m. Sounds good, Your Honor. I'll send that email right now.
All right. Any other cases for either counsel?
No, Your Honor.
Good to see you both. Have a great day.
Thank you, Your Honor. Have a good day, sir.
In person, counsel David Gonzalez, page 3, number 8.
Melissa Michelle Cepeda versus Benigno Gerardo Cepeda, cause number 2026, FLA 391C3. Court marks Mr. Gonzalez. Welcome to court. The court marks you present in person. Mr. Villafranca, are you present? Court marks Mr. Villafranca not present. Melissa Cepeda, Benigno Cepeda, are you present?
Not identified.
Court marks neither party present. Counsel, what is the announcement?
We filed an agreed motion for continuance. I'm just here to make the announcement. We have maybe another setting in the next week or two. And then Mr. Villafranca is in federal court.
Right. Court has signed that motion for continuance. Court has written in that court finds that counsel is unavailable due to another court setting. So two things. First thing, Ms. Flores, give us another TRO temporary order setting.
May 5th at 2 p.m.
All right, so we'll come back on that setting on May the 5th. Second and last thing, Mr. Gonzalez, I think this is your first appearance on the family law docket.
Yeah, I believe so, yes.
Welcome, Mr. Gonzalez. Mr. Gonzalez, will you be making a reoccurring appearance on this docket?
Yes, sir.
Okay, I'm going to add you to the attorney ad litem list. So expect to meet with children, parties, parents, and litigants soon. I was glad to welcome people to that list.
Thank you.
All right. Anything else on this case, Mr. Gonzalez?
Nothing further.
All right.
Excuse.
Yes. Have a good day. Good to see you.
You too.
Next in person, counsel Nathan Chu, page 2, number 5.
Ashley Anali Martinez versus James Castañeda, cause number 2024, FLA 1863C3. Court marks Mr. Chu present in person. Mr. Ruben Arce present in person. Julio Garcia, are you present?
Identified.
Court marks Mr. Garcia not present. Ashley Martinez, James Castañeda. Any parties present? Court finds.
Ashley Martinez and James Castañeda online.
Are you Ashley Anali Martinez?
Yes, Your Honor.
Welcome to court, Ms. Martinez. Court marks you present. You're participating by video conference. As you can see from your device, your lawyer is present in court. James Castañeda, I need you to unmute your device, please. Are you James Castañeda?
Yes, Your Honor.
Welcome to court, Mr. Castañeda. The court marks you present in person. Court marks you present by video conference. As you can see from your device, your lawyer is present here in person. Mr. Arce, Mr. Chu, what is the announcement?
Good morning, Judge Nathan Chu present for Mr. Castaneda. We have pinpointed the problem and we've spoken to each other. I think we've reached a resolution. The children right now are in split custody, 1 week with dad, 1 week with mom. So we're working on the offset child support. So my client makes more money than Ms. Martinez. So the offset child support that's going to Ms. Martinez should be $750 a month, Judge, based on my client's earnings. Since the temporary orders in July until present, he's been paying $1,050. So we're asking for a rebate of $300, about 8 months, so about $2,400. So those are the only two changes we need to make in the proposed order.
Mr. Arce?
Judge, and we were doing the math, and I think that's what it works out to, Your Honor. So,
Oh, and that's why you're set for entry.
yes, sir, there was just that one issue, Judge, as far as the offset, but we've kind of come together to resolve it.
We had a hard time mathing, but it
Sure.
came out today.
I can't fault any person for that. So let me ask you all this. So are you telling the court that you have concrete terms that just haven't been reduced to writing?
Everything else has been reduced to writing. It's just the offset number, which we have it today that we entered. We spoke to the court.
Right. So you're telling the court you have the hard numbers, they just haven't been put on paper yet.
That's what we're telling the court.
Okay.
And Judge, prior to today, I think that Mr. Chu had submitted a decree, but it just does not have the correct calculation. So we would just ask the court not to sign that
Okay.
until we submit a new decree with a modified change.
All right, let's do one more. And let's do two things. Give me an entry of judgment date, Ms. Flores. One more.
And how much time you on?
Yeah, give me, if they have the numbers, give me 2 to 4 weeks. No more than 4 weeks. Whatever date we have, you can push it on.
That'll be May 5th at 2 p.m.
And then give me an orders due, which would be after May the 5th.
May 18th
Right.
at noon by submission.
All right, so what this all means, Mr. Chu and Mr. Addis, is that you need to file your final agreed to order on May the 5th. If for whatever reason that still doesn't happen, you can still do it by May the 18th. The thing is, after May the 18th, this case is just going to go inactive to give you all the time you need to run the numbers, whatever time that is. It just goes inactive until you make another request to the court.
Yes, sir.
Anything else on this case?
Judge, will we have to be present on the 5th, or that's just a submission date?
Well, it's an in-court date, but if you file it before, no need to attend.
Yes, sir.
Ms. Martinez, do you have any questions for the court?
Sorry, I couldn't figure out the mute. No, Your Honor, I don't. Thank you.
Mr. Castañeda, do you have any questions for the court?
No, Your Honor.
All right, Ms. Martinez, Mr. Castaneda, congratulations to working out and working through your disagreements with each other and through your lawyers. I can tell you that I really disfavor the split custody, but I'm not here to do what I want. I'm here to do what's in the best interest of these children, and you know that better than others than anyone else. So I'm happy to approve your agreement because you know your family circumstances and situations. So congratulations to each of you on resolving your situation. I'll sign your decree or final orders on May the 5th, unless they come in sooner. I wish you and your family very well. Have a good day.
Thank you, Your Honor.
Next case for Council Chu.
Thank you.
Number 7.
Thank you.
That's Jorge Chong versus Alejandra Chong, cause number 2026 FLA 284C3. Court marks Mr. Chu present in person. Ms. Benavides Maddox, are you present?
Present.
Court marks counsel not present. Speak into a microphone and tell the court, are you Jorge Chong?
Yes, señora.
Hable ante el micrófono y diga si usted es Chong.
Sí.
Yes.
Welcome to court.
Bienvenido al tribunal.
You're in person.
Usted está en persona.
Your lawyer is on your right.
Su abogado se encuentra a su derecha.
Alejandra Chong, are you present?
Identified.
Court marks respondent not present. Mr. Chu, what is the announcement?
Your Honor, I spoke to Ms. Benavides Maddox this morning for the temporary orders, and we were in agreement to the temporary orders. And the terms are as such, Judge, that Mr. Jorge Chong and his wife, Alejandra Chong, are both named temporary conservator of the children. Their agreement is that both parties will reside together at the house. And Mr. Chong will continue to pay the mortgage and the house bills. And then that's it for the temporary orders, Judge. Everything else remains the same. And then
Con la abogada Benavides Maddox en cuanto a las órdenes temporales y hemos llegado a un acuerdo en cuanto a los términos de las órdenes temporales, en las cuales el señor y la señora serán interpuestos como conservadores temporales de los menores y ambos estarán viviendo con los menores en la casa. Sin embargo, el señor Chong será responsable de pagar la hipoteca y los pagos de la casa.
Mr. Chong, would you raise your right hand?
Chong, levante su mano derecha.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Jura o afirma que el testimonio que dará ante esta causa será la verdad bajo el amparo de Dios. Yes.
You may lower your hand. Is your true and correct name Jorge Chong?
Su nombre correcto y verdadero es Jorge Chong.
Sí.
Yes.
Mr. Chong, how many children do you have with Alejandra Chong?
Señor, ¿cuántos hijos tiene usted con la señora Chong?
Dos.
2.
Did you hear the agreement that was told to the court by your lawyer?
¿Usted escuchó el acuerdo que se dictó ante el récord por medio de su abogado?
Sí.
Yes.
Is that your agreement with Ms. Chong?
¿Es este su acuerdo con la señora Chong?
Sí.
Yes.
Is at least temporarily, is that your agreement, your full agreement with her?
Temporal. ¿Es este el acuerdo total?
Sí.
Yes.
Was there anything left out?
¿Se dejó algo fuera?
No.
No.
Is there anything you want to change?
¿Hay algo que usted desee cambiar?
No.
No.
Do you believe that this agreement is in the best interest of your two children?
¿Usted que eso está en el mejor interés de los menores?
Sí.
Yes.
Court finds that it is in fact in the best interest of these two children. These are the temporary orders of the court. These orders are due to the court honor before
April 27 at noon by submission.
Estas órdenes temporales deberán de ser entregadas antes del 27 de abril debido a que se halla que están en el mejor interés de los menores.
That concludes your hearing, Mr. Chong. Do you have any questions for the court?
Eso concluye la audiencia del día de hoy. ¿Alguna pregunta para el tribunal, señor Chang?
No.
No.
Keep in contact with your lawyer. Ms. Chong will do the same with hers.
Manténgase en contacto con su abogado. El abogado Chang, la señora Chang hará lo mismo con la suya.
We'll see you on May the 19th. Good luck.
Es el 19 de mayo. Buena suerte. Those are all the matters before the court for counsel Chu this morning.
Good to see you, Mr. Chu. Have a great day.
Good to see you, Judge. The feedback from my high school student was that this court had the best visibility because they're able to see on the TV and hear everything that was going on compared to the other courts, because the other courts, they were just sitting behind and they couldn't hear the conferences up. So the speakers and the
interesting.
TVs really helped them engage.
Oh, that's interesting. Thank you for that feedback, Mr. Chu. Thanks.
And next in person is counsel absent, page 4, number 9.
This is Christian Quesada versus Robert Solis, cause number 2026, FLA 506C3. Court marks Mr. Arce present in person, Mrs. Cotto present by video conference. Good afternoon. Good morning, Mrs. Cotto.
Good morning, Judge. Sorry about that. I was in another court, but I'm here.
Court marks you present by video conference. Mr. Arce is present in person. Christian Quesada, Robert Solis. Are you Christian Quesada? Unmute your device, please.
Yes, I'm Christian Casada. Judge.
Welcome to court, Ms. Quesada. The court marks you present by video conference. As you can see, your lawyer is present in court. Robert Solis, are you present?
He's not present, Judge.
So noted. Counsel, go ahead.
Judge Madeline Escoto for Mr. Solis, Judge. I prepared a settlement offer to Mr. Arce. I'm pleased to announce that we have signed that settlement proposal and that has been filed with the court, I believe, yesterday. We're asking that the court sign the same, and those will be the temporary orders of this court.
Mr. Arce.
Ruben Arce for Ms. Quetzada. That's correct, Judge. Myself and Mrs. Cotto have been working on that settlement agreement, Judge, and we did come to an agreement late yesterday, Judge. So that is our agreement as submitted, Judge.
Court has received, reviewed, and considered the Rule 11 agreement. It is signed by both counsel. The court has signed off on it. The court is tendering that original signed copy to the clerk's office. These now become orders to the court that are due on or before
May 18th at noon by submission.
May 18th. Okay.
Yes, Your Honor.
Just wanted to confirm. All right, May 18th by at noon by submission. You'll come back to court, Ms. Quesada, on June the 18th at 9. Ms. Quesada, do you have any questions for the court?
No, Judge.
I wish both you and Mr. Solis well. Keep in contact with your lawyer so that you're ready to go on June the 18th. By the way, congratulations, Ms. Quesada, to you and Mr. Solis. Not everyone has the opportunity or the fortune to resolve everything by agreement well before the hearing, although I hear you people were working late at night. But congratulations on this good resolution. Good luck
Thank
to
you.
all.
Those are all the matters before the court for counsel absent.
Your Honor, be excused.
Good to see you, Mr. Arce. Have a great day.
Likewise, thank you, Judge.
Next in person is counsel Javier Guzman, page 1, number 2.
Bradley Paul Johnson versus Sandra Johnson, cause number 2000. I have no idea what that is. It's hole punched through some case.
2021 FLA 100C3.
So called. Good morning, Mr. Guzman. Court marks you present in person. Good morning, counsel.
Good morning, Your Honor. Rudy Santos on behalf of respondent, Ms. Sandra Johnson.
Mr. Santos, welcome to court. The court marks you present by video conference. Are you Bradley Paul Johnson?
Yes, Your Honor.
Understood. Welcome to court, Mr. Johnson. Court marks you present in person. Are you Sandra Johnson?
Yes, Your Honor.
Welcome to court, Ms. Johnson. Court marks you present and participating by video conference. Both parties, both lawyers present before the court. petitioner and counsel in person, and respondent and counsel by video conference. Counsel, what is the announcement?
Your Honor, we are asking for time in this case. We were retained just yesterday. We did file a verified motion for continuance. This is a case where extraordinary relief was granted, but we don't believe it's warranted. We would like the court's earliest available hearing so that we can go ahead and have this matter heard, but we just need some time to prepare.
Response, Mr. Guzman.
Judge, I'm set for a jury trial on Monday. It's an intoxication manslaughter in the 111th District Court. And then I have a subsequent trial the following Monday in the 341st on an aggravated sexual assault of a child.
There's no rest for the weary.
Yes, Judge.
It's a very busy trial schedule, Mr. Guzman.
Yes, Your Honor. And so I'm sure Your Honor read the unsworn declaration that we filed with our temporary restraining order. I did feel that the extraordinary relief was warranted. And so we are asking for a hearing, preferably today. I understand that Mr. Santos just got hired, but if we're gonna move it, I would just ask that it be moved. I mean, the next 2 weeks, I'm gonna be busy, Judge. So as long as it's either after that or and that the temporary restraining order remain in place or prior to those two trials, then I would be good with that.
Your Honor, our concern is that we don't believe that it's warranted. The only allegation is as to an alleged incident where there was an arrest, no charges, it was isolated. Right now we have a TRO preventing all contact and all possession. We would ask for the court's earliest available date. We are willing to accommodate Mr. Guzman in his schedule, of course, within reason.
So I guess what I'm hearing, Judge, is that maybe after both trials, the second trial would presumably last 4 days. So that would be by the 7th of May, that would probably finish, maybe the 8th. So we could have the hearing the 11th of May.
In June would probably be the next setting after that. So, I mean, so multiple things going on. So on the one hand, we have a motion for continuance filed by Mr. Santos. This is number one, a first setting on this matter, which is TRO, temporary orders. First settings have that by policy of the court, that courtesy. Number two, it's Mr. Santos' first appearance by policy of the court. Court gives deference to give all persons the ability to lawyer up, as it were, and be prepared in preparation for defense of their case. So there's two reasons why the court should grant it. So if the court extends that courtesy to one side, then it should do the same to the other side. And in response, Mr. Guzman says, well, I don't mind giving him that courtesy, but either we go forward today or now you accommodate my schedule, which is an unavailability beginning on the week of the 27th, and then unavailability again on the 4th. So now we're looking at the court schedule, and now we're looking at sometime in late May or June.
I'd be good with either one of those dates, Judge.
Mr. Santos.
Your Honor, that's a long stretch for the child to be away from mom. It's very difficult.
I don't disagree with that. You tell me what to do with that. It's your request for more time.
I'm sure we can confer, Judge, prior to that, and maybe we can work something out, hopefully before then.
Ms. Flores, if we push this on to the next available date, which is May 19th, how many cases do we have set that day?
May 19th, we have 22 cases.
I'll set it for May. That's a very first day, but with 22 cases, I can tell you, and what time? That's at 2 p.m. So very unlikely that we'll be out before 6 p.m. on that day. I tell you what, Ms. Johnson, Mr. Santos, I'm going to set this for May the 19th at 2 p.m., but I'm going to order that this be held in person, so that if Mr. Santos or Mr. Guzman are the first to arrive in person, first in, first out. So again, I'm ordering this in person so that if you need that setting, you have a better chance of being called first and not being called at 7 p.m. Thoughts, comments, questions, or objections, Mr. Guzman?
No, Judge.
Thoughts, comments, questions, or objections, Mr. Santos?
None, Your Honor.
I guess the only thing, Judge, would be if we can get an extension of our TRO for 2 weeks. We'll file that order today.
Any objection, Mr. Santos?
We would object, Your Honor.
Well, by policy of the court does unless we have a hearing. So I mean, I guess I do by agreement, but in order to extend it, then I'd have to have a hearing. There is a request and there is an objection. If you all stick to those positions, this will be the second contested matter on the court's docket. Any movement one way or the other? All right. So this is the second matter that the court will hear on this docket. Stand by.
Thank you, Judge.
Next on line is Counsel Madeline Lopez Escoto, page 4, number 10.
Juan Arellano Jr. versus Emily Arellano, cause number 2026, FLB 22C3. Court marks Mrs. Scotto present by video conference. Andres Reyes, are you present? Court marks Mr. Reyes not present. Parties, Juan Arellano, Emily Arellano, are you present? Court finds the parties are not present. Mrs. Scotto, go ahead.
Good morning again, Judge Madeline Escoto for Mr. Arellano. Judge, on this particular case, Mr. Reyes and I were able to finalize the case by agreement. We have e-filed a binding Rule 11 agreement, Judge, with all of the terms having to deal with the division of assets and debts. Our hope is that the court will sign it and the attorneys will prepare a decree with the affidavits of prove-ups as well as the companion special warranty deed.
The court in cause number 2026, FLB 22C3, has received, reviewed, and considered a Rule 11 agreement signed by both parties. It is in due form. The court has signed it. The court is tendering the original to the clerk for processing. Mrs. Cotto, are you requesting an entry date for a hearing or just an orders due?
Orders due date, Judge.
All right, these are the orders of the court. The orders are due on or before
May 18th, noon by submission.
Ms. Escoto. That concludes this case, and let me just put on the record that this is now one of many cases that were resolved in a very expeditious manner. I'll put on the record, you make it look very easy, and I can't imagine that it is. But
It's not, Judge.
thank you
Yeah.
for all that work before coming to court. Thank you.
I appreciate it, Judge. Thank you. And that's all I have with the court. May I be excused?
Yes, have a good day.
You too, Judge.
Page 2, number 4.
Paulina Angelica Munoz versus Jose Ines Munoz, cause number 2022, FLB 1090C3. Guillermo del Barrio Juan Hernandez. Any lawyers present?
Counsel del Barrio called in that he was running behind schedule, Your Honor. Would be in shortly.
One lawyer, Mr. del Barrio, called to advise that he was running late. Mr. Hernandez is not present. Parties, Paulina Angelica Munoz, Jose Ines Munoz. Any parties present?
Not identified.
Court finds no parties are present. This is a motion non-proton.
Your Honor, if I may,
Yes.
we did receive a proposed agreed final decree. Of course.
Now, I've been handed that proposed it's agreed to. It's entitled agreed. It's not signed by the lawyers. Has any person, party, litigant, or lawyer filed an objection?
No, Your Honor.
The court has received, reviewed, and considered that agreed final decree of divorce. The court has signed it, and that concludes this case. The court is tendering that original signed copy to the clerk's office. Thank you.
Recalling counsel Guadalupe Castillo, page 3, number 6.
Jorge Martinez, Denise Marie Salinas, cause number 2025 FLA 1199C3. Court marks Mr. Castillo present in person, Ms. Soto present by video conference. Neither of the parties present. Mr. Castillo, Ms. Soto, what is the announcement?
Judge, we are very close to finalizing this case. I think we only have two issues, the division of the $28,000 that netted from the sale of the home, which is in the registry of the court for division. And then the amount of child support together with arrearages. And that's what we would continue working on. We have exchanged written settlement proposals. Both Ms. Soto and I have been working fine. And we're very close, Judge. We do need maybe a couple of weeks. We looked at our calendars and maybe May 13 or May 20. But if the court wants an earlier setting, of course, we'll have to abide by whatever the court said.
Ms.
That's correct, Your Honor, except May 13th, I would only be available in the afternoon. As I have a federal sentencing at 9 a.m. that morning. I'm not quite sure what time I'll finish.
I don't think either party going to find any judges. I'm sure there's going to be one in town, but I don't think there's going to be many judges in town on that day.
On those days?
Yeah. But I tell you what, let me ask you this. So I think the court heard earlier that this was not going to be a jury trial, rather a bench trial. And it sounds like if there's only these two issues, even if you don't reach a final resolution, and I expect that there's a good chance that you'll at least be so ready for that hearing because you've fleshed these things out amongst yourselves. So let me see if I can give you that the next available date. The very next available date after today is May 19th. And it sounds like if you only have these two issues, one more time, it's very likely you're going to reach an agreement. And if you don't, it sounds like you're going to have fleshed that out so much that you'll go straight into a final hearing. So let's do May 19th at 2 p.m. Ms. Flores, cap these cases and remind me that I've capped them so I don't do that again. I've done it twice now.
For May 19th, okay. No matter for
Oh, the jury
That is
selection
correct.
conference. You are absolutely right. We'll convert that into a final hearing. Okay, so I'm not adding to our caseload on that day. Very nice. Mr. Castillo, Ms. Garcia, anything to add?
Your Honor, the only thing to add from the AG's office, we have not intervened in this divorce, but the prior SAPSA order is out of County Court 1. It is running. There are some arrears. If the attorneys can file to transfer and consolidate the SAPSA, that cause number is 2024 FLI 001427C1.
You know, I think if you all do this relatively soon in the next week or so, week and a half, I would hope that either Judge Leti Martinez or Judge Hugo Martinez can sign it so that on the day of the final hearing, they'll be consolidated. Mr. Castillo, Ms. Soto, who here can prepare that request, the agreement to transfer?
I can prepare it, Judge.
All right. Prepare it, file it with County 1, prepare a request to transfer and with an order and then an order accepting so that when we come back on May the 19th, it'll be straightforward.
Okay.
All right. Thank you for that, Ms. Garcia. Ms. Soto, Mr. Castillo, anything else on this case?
not for me, Judge.
No, Your Honor.
All right, Ms. Soto, Mr. Castillo, Ms. Garcia, always good to see you. Have a great one.
Thank you, Judge.
Thank you. You too, Your Honor.
That leaves one matter pending before the court. Page 1, case 2, Bradley Johnson, Sandra Johnson, cause number Tell me that cause number.
It's 2021 FLA 000-100C3.
All right, court marks Mr. Guzman and his client present in person, conferring but coming before the court. Mr. Santos and his client are present by video conference. I'm gonna ask that you start your videos and staff to prompt those videos. Court is asking Mr. Santos and his client to turn on their videos and start their device. I guess let me put this case on pause for 1 second. Mr. Del Barrio has arrived. Page 2, case 4. Mr. Del Barrio, court called this case earlier. There was an agreed motion on pro tunc. There was no objection. I signed off on it. That concludes this case.
That's exactly what it was literally missing a number on the pin. So I could do that for.
Agreed to no objection. We're good.
Yes.
Happy birthday to her. Have a great day. All right, that leaves just one case before the court. Johnson v. Johnson, cause number 2021 FLA 100C3. Mr. Guzman and his client are present in person. Mr. Santos and his client are present by video conference. Mr. Guzman,
I think we may have reached a temporary agreement, Judge, and I think Mr. Santos can tell the court, but it would be a supervised visits on Saturdays from 11 a.m. to 7 p.m. Is that correct, Mr. Santos, or no?
That's not correct. I still need to, I have to run that and get authority from my client, but we are looking at potentially working it out. I believe my client works on Saturdays. If we can agree to maybe Sundays, that would perhaps work. And we would have to talk about the terms of visitation, et cetera. But we're pretty close, Judge.
Can we get 5 minutes, Judge?
yes, I will come by on the bench in about 5 minutes. All right, we'll stand at ease momentarily.
Thank you, Judge.
Thank you, Your Honor.
Please be seated. Good morning. Court is back in session. This is the family law docket for Wednesday, April 22nd, 2026. Time is now 10:46. There is one case pending on this morning's docket. Johnson v. Johnson, cause number 2021 FLA 100C3. Present in person are Mr. Guzman and his client, petitioner Bradley Johnson. Also present by video conference are Counsel Rudy Santos and his client, respondent Sandra Johnson. Mr. Guzman, Mr. Santos, what is the announcement?
Luckily, the parties were able to confer and reach an agreement on temporary orders with regard to possession and access of the child. And the agreement with respect to possession and access will be that the child is going to be remaining with Mr. Bradley Paul Johnson in the interim until we can have our next hearing. But during that time, my client's going to have visitation with the child on the first, third, and fifth weekends, both Saturday and Sunday, between the hours of 2 p.m. and 8:30 p.m. The visitations will be supervised at a public location, but there will be plenty of integrity allowed with respect to the visitation. There won't be any interference. Mr. Johnson will maintain a reasonable distance. He's not going to eavesdrop or spy on conversations. Mom's going to have an opportunity to actually interact with child. And additionally, Your Honor, we have agreed that until our next hearing, there will be daily electronic access to the child from the hours of 8 p.m. to 9 p.m.
Mr. Guzman?
Correct, Judge.
Let me ask you both this before I ask your client some questions. Mr. Santos, Mr. Guzman, you mentioned a public location. Is that location specific or is it determined by the parties later?
So we had suggested main event, Judge. I don't know if Ms. Johnson has any objection to that.
My only concern, Judge, is that there would be some fatigue, maybe 6 hours, 6.5 hours at main event. I don't know if everybody's going to be up for that or if the child might lose interest. So I would hope that the parties can communicate somewhat. And if it's at a different public location, maybe they can agree to that.
That's fine with us, Judge. I mean, that's fine. We can agree to some other public place.
Mr. Because you've done a lot of speaking, Mr. Santos. Mr. Guzman, how many children before the court?
One,
Age,
12 years old,
gender?
female.
Court is racking its brain for places that a 10-year-old female would enjoy in addition to main event, because all 12-year-olds being equal and everybody's different, but in general, the repetitive nature of that, I can understand how no one 12 or anyone else would like repetitive Saturday and Sunday now. In a second. A 6.5-hour visit. Mr. Santos, Mr. Guzman, remind the court, there is a Chuck E. Cheese near in the same mall. What is the name of the other pizza location on I-35 next to GB on Calton? Peter Piper's. Peter Piper. You're coming back. Miss Flores, give me a, oh no, we have a final, we don't have a final. When is the final hearing date? Give me a final hearing date. 12-year-old, we want to do sometime after she is done with this school year. So give me sometime in June.
June 16 at 2 p.m.
All right, so let's do this. Well, Mr. Johnson, Ms. Johnson, please raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
Both have answered yes. You may lower your hands. Mr. Johnson, let me begin with you. You're the petitioner. Is your true and correct name Bradley Paul Johnson?
Yes, it is good.
Mr. Johnson, did you hear the agreement that was told to the court by Mr. Santos, Ms. Johnson's lawyer?
Yes, Judge.
Is that your agreement? And they're only temporary, so they're not meant to be permanent, but at least between now and June the 16th, these are the orders. Is that your agreement, temporary agreement with Ms. Johnson?
Yes, sir. I'm pretty open with that.
And is this your full agreement with her? Was anything left out?
No.
Is there anything you want to change about that agreement?
No, sir, I think that's fair until we get our agreement.
And do you believe that this is in the best interest of your 12-year-old daughter?
I do, Your Honor.
Same questions to you, Ms. Johnson. Is your true and correct name Sandra Johnson?
Yes, Your Honor.
Ms. Johnson, did you hear the agreement that was told to the court by Mr. Santos, your lawyer?
Yes, Your Honor.
Is that your agreement with Mr. Johnson?
Yes, Your Honor. Can I add something?
Not yet. Was anything left out of this agreement?
No, Your Honor.
Is there anything you want to change about your agreement?
Not that I want to change.
All
I
right.
just want to,
Do you believe that this agreement is in the best interest of your daughter?
yes, sir.
All right. What is it that you want to tell the court?
Main event, Chuck E. Cheese. I know she's grown kind of out of Chuck E. Cheese,
All right,
and
pause.
main
Let
event
me
is really loud.
let me do my thing, and then I'll give you a chance to chime in. Right.
Okay.
So the court hereby adopts and approves your agreement and finds that it is in the best interest of your daughter. These are the temporary orders of the court, and the orders are due on or before
May 18 at noon by submission.
get them submitted as soon as possible, because and hopefully you can do that, Mr. Santos, before the end of the week, so that I can sign them. So let me see, when is the next visit? First, second, third. Okay, so you have a week before the next visit, so this is good. So file them hopefully before the end of the day on Friday or Monday, so that I can sign them off. Now, let me add to your agreement and see if this is agreeable. Mr. Johnson, Ms. Johnson, I look, without knowing anything about your daughter, other than she's 12 years old, and if all other things being equal, even if she wasn't 12, if somebody were to go to the same place over and over, they'd probably get tired. So my suggestion is this, and I'll see if I can get you all to agree. If Ms. Johnson provides you 24 hours notice, Mr. Johnson, would you have any objection to the visits taking place at either Main Event, Chuck E. Cheese, which is in the same facility as the first, McDonald's on I-35, and Del Mar, which is the nearest McDonald's closer to that location, I think, the movies, which is the UA Cinema, in the same location, but should have to tell you what movie that is. And if they want to continue that visit, I think the food court could be available. I don't know. The other place that occurs to the court is Fuddruckers. And I think, as you all mentioned, Peter Piper, which is the other pizza facility nearest to the one that you all mentioned. First question, Mr. Johnson, would that be agreeable to you?
Yes, Your Honor.
Would that be agreeable to you, Mrs. Johnson?
Yes, Your Honor.
All right, Ms. Johnson, okay, the court hereby adopts and approves that. You just need to let Mr. Johnson know 24 hours in advance where that is going to be, and don't make any changes. Just stick to that, please, so that there's stability in this process. Now, Ms. Johnson, knowing that this is agreeable and that that's going to be put into the orders, is there anything else you want to tell the court?
No, Your Honor.
Does that resolve your question or statement?
Yes, it does. I just want to take her where she wants to go, I guess. Wherever she feels comfortable.
I'm going to limit you to these
Within,
places because they're that, and that's why I'm being very specific, but at least you can converse with her during your electronic daily communication between 8 and 9. Where would you
yes,
like to go on Saturday? Where would you like to go on Sunday? Make sure you put that in writing by text, close app, or some documentation of some point to give Mr. Johnson some notice that he needs to take your daughter to that place and supervise the visits from afar. And there shouldn't be any problem, and nobody will get bored of visiting the same places over and over again.
correct.
Perhaps maybe sending over like an itinerary, 24 hours in advance.
Well, just the location. I don't know that he needs to know exactly what they'll be eating or doing, but just advance notice in the interest of fairness and stability, and in the best interest of this child. The court orders it in the best interest of this child. The orders are due as soon as possible. Mr. Johnson, do you have any questions for the court?
No, Your Honor.
Ms. Johnson, do you have any questions?
No, Your Honor.
I wish you both very well. More importantly, I wish your daughter all the best. Ms. Flores.
The final hearing, Your Honor, will that be an in-person hearing?
Yes, on June the 16th at 2, make sure everyone is present in person. And we'll proceed. Good luck to you on your trials, Mr. Guzman.
Real quick, Judge, we requested a guardian ad litem and a child custody evaluator. I think the court is gonna probably need to hear from somebody at the finality of this case. I don't know if we can appoint somebody. I know that Armando Lopez was the child's guardian ad litem during the divorce. I know Mr. Santos has an objection to that. We don't mind having somebody else, but I think we do need a child custody evaluator at some point because the conservatorship will probably be at issue at the end, Judge. And so just so we can start getting ready for that.
I ask these questions and with all sincereness. Who's paying and who's waiting? So first question, this child custody evaluator probably isn't going to be less than 1,000, could be upwards. And who's going to wait that long? I wouldn't expect any child custody evaluation to be ready before August. So you're probably going to go into the next school year without a final resolution to this case. If everybody is under that impression, understanding, I'm okay with that. I just don't want the impression to be that I'm going to make a ruling right now and this thing is going to get resolved in summer. You're going to go into next school year without a final resolution. So full disclosure, thoughts, comments, Mr. Guzman.
Well, at the very least, a guardian ad litem then, Judge, just so that the court can have eyes and ears with the child and that that guardian ad litem can report to the court at some point.
Same question, Mr. Santos. Thoughts and comments?
Your Honor, we just don't want anything to prolong this. Like we were saying, we wanted the next available date. If the court finds that a guardian ad litem is necessary at this point, we just ask that petitioner cover the costs. It's not something that we were prepared for today. I haven't even had an opportunity to talk to my client about that issue yet.
That's a little different. I mean, unless there's an objection, it's 50-50, and then you have to come up with some, and there's probably 1,000 good reasons to do something that's different than 50-50, but I mean, the standard is, or the knee-jerk reaction is just 50 each.
And
I just wanted to get her authorization, Judge. I don't mean to be an obstructionist. I just don't want to do anything without having my client's full.
That's very fair. Very, very fair. I don't fault. I'm just thinking out loud. I tell you what, folks, this child is 12, over the age of 12. So let's do this without knowing anything else. I am going to schedule an interview with this child on that date, as I always do, June the 16th at 1 p.m. If there is an agreement, you need to let the court know so that I can do something else. Work on orders, get ready for the hearing at 2 p.m. You need to let this court know we've resolved it on our own and we're not bringing in the child because we have an agreement. If we don't hear from any person, then we know there isn't an agreement, and the former ad litem, my now staff attorney, my court coordinator, and I will participate in this interview with this child. Now, if between now and then, any person, Mr. Guzman on behalf of his client or Mr. Santos on behalf of his client would like to file a request for an item, file it with the court, we'll get it set for hearing, but at least Ms. Johnson and Mr. Johnson know that I'll have the benefit of talking to this child. Done this long enough to, I'll be able to figure out where we're at.
Yes, Your Honor.
Anything else on this case, Mr. Guzman?
Nothing further, Judge.
Mr. Santos?
Nothing from us, Your Honor.
Do you have any questions for the court, Mr. Johnson?
No, Your Honor.
Do you have any questions for the court, Ms. Johnson?
No, Your Honor.
I wish you both very well. More importantly, I wish your daughter all the best. Have a great day.
Thank you.
That's all I have before the court, Your Honor. May I be excused?
It's good to see you, Mr. Santos. It's good to
You
see
as
you,
well.
Mr. Guzman. Have a great day.
God bless you all. Thank you.
Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor.
This now concludes this docket held in person and by video conference for Wednesday, April 22nd, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. The court thanks you all. Have a great day.